Welcome to Notable Approvals. I am attorney Amanda Shaffer. Before I get to our case today, just a reminder, let me shut this off. Just a reminder to like us, follow us on Facebook, Instagram, YouTube, LinkedIn, all of that, so that you don't miss any of our lives. And one more thing before I get to our case today, happy International Women's Month. And in honor of that, I got this new poster here with some famous women. We got Frida Kahlo, Maya Angelou, Amelia Earhart, and of course, RBG, Justice Ruth Bader Ginsburg. Just reminding us women to be strong, be brave, be humble, and be badass. All right, let's get to our case today. This is a weird one. This is for a client who is a native and citizen of Ghana. And it's a weird one because of what kind of went on with this case. So it should have been a straightforward marriage, a green card based on marriage. However, what happened was let's start from the beginning of his history here. He entered the U.S. in 2015 with a B2 visitor visa, and then he married a U.S. citizen in 2017. He actually, when he was back in Ghana, worked for what is their equivalent of the FBI is. That's not relevant, just a fun fact. And then she applied for his green card, and they had their first interview in May of 2018. I attended the interview with them. The officer at the interview decided they needed to have another interview. So basically a Stokes interview, although it was in Newark, not in New York City. So for the second interview, Aaron, he was attending with them, and our client's wife was 3 hours late to the interview. Now, that means she did not attend the interview, and the interview was missed. And because the interview was missed, unfortunately, the case was denied. They waited and waited and waited for her, but the reality is when you get that interview notice, you can't be late. They give you maybe up to 15 minutes if they're, maybe some offices will give more, but for the most part, don't be late, be early. And if you're 3 hours late, the hope was that they would reschedule it, but they didn't reschedule it, they just denied it. And then very quickly, USCIS placed him into removal proceedings about a month later. So that was December 2018 when he got placed into removal proceedings. So we immediately refiled the I-130. Now, we couldn't file the marriage petition with the green card application this time because he was in removal proceedings. So we had to file the I-130, which is the marriage petition. Then once we got the receipt notice, we could then file the green card application with the judge. So we file the I-130, and then we go to court. And to our surprise, I had told my client, look, they used to terminate cases like this after the I-130 was approved, so you can get your green card with USCIS, but I can't guarantee that because they haven't done that in 4 years, or whatever the case may be. Or actually, back then it was 2 years, 2.5 years. So we go to court, and to my surprise, the attorney for the Department of Homeland Security says that she is going to agree to termination if the I-130 is approved. And what that means is that it saves my client money, it saves my client time, presumably should get his green card quicker because it's usually a lot sooner to get an interview with USCIS than it is to get an individual hearing with the immigration court. I have a question here before I continue. Let me see what this is. My son is married to a Mexican lady in Mexico. They have 2 children. What's the best path for them? Well, Condi, I am not taking questions about other cases in this live right now, but if you could see our contact information at the bottom of the screen scrolling across, our phone number and email, reach out to me, please, and I'll be more than happy to help you after I finish the live. And I'm assuming your son is a U.S. citizen. If he is, then that will not be a problem at all. If he's not, if he has a green card, should also not be a problem. And if he's not, then I'm not really sure, but we can talk about it. Okay. So as I was saying, we go to court, and the judge says to me, we're going to give you an individual hearing, but if the I-130 gets approved before your next hearing, then file a motion to terminate. So in February 2019, which was around the time of that hearing, I think we did it right before the hearing, we filed the I-130, and then in October of 2019, it gets approved without an interview, which was very nice. You're welcome, Candy. Look forward to speaking with you. So when the I-130 gets approved, I think I said an individual, I think he had another master hearing in like January, I don't remember. It was like a year later. We get the I-130 approved. I file a motion to terminate with the court. We don't get a response. And that's common. They're very backed up with motions, or even more backed up now. So we have to go to court. So we go to court the day that's on the hearing notice. We get there in the morning, and I go to check in, and the clerk says, well, you're not on the calendar. I'm like, here's the hearing notice. I called, we're on the calendar. She says, no, you're in the afternoon. And I was like, well, that's annoying, because it was in Newark. If it was in New York City, where my office is, it's a 15-minute walk. I could go back. But in Newark, going back and forth isn't going to happen. So I was like, well, this is very frustrating. We're here because we filed a motion to terminate, and we never got a response. So she told me to go in and talk to the judge. So I did. I had to wait, there was an individual hearing going on. I waited, and I went up to the judge, and I explained the situation. And the judge said to me, well, he apologized for the mistake with the calendar, and said, why don't you go downstairs, talk to the trial attorney, and if they're going to agree to terminate, because they hadn't filed an answer at all, then we'll terminate. But I can't do it until the afternoon because I don't have the file yet. So, okay. So I go downstairs. I speak to the Department of Homeland Security attorney. He reviews the case very quickly, sees my client has no criminal history. The I-130 was approved. His only immigration violation was overstaying his visitor visa. So he says, yeah, we're not going to oppose this. Not a problem to terminate. We will let the judge know when we get upstairs. So I had to wait till the 1 o'clock calendar. And 1 o'clock comes around. We go up in front of the judge. The judge asked DHS on the record, are you going to consent? They said yes. And the judge says, okay, I'm going to terminate. Now, the judge, for some reason, still didn't have the file. But the judge had given me an order. He wrote it. When you submit a motion to terminate, you submit 3 proposed copies of the order. So the judge can use your copy if you want. So he did. He signed what he said. Take out one of your copies. I will sign it, give it to you. I'll put the other one in the file. Great. We leave. My client's case is terminated. Then we get a letter from USCIS that says, okay, your case has been transferred back to us from the courts, which is great. We need you to file a new, I think they wanted a new green card application, a new affidavit of support, and you have 30 days to do it. Okay. So we do it, and we get it in there on time. And then not long after that, what ends up happening, which was weird, hi, Manuel, thank you for watching, is that we get another hearing notice from the immigration court saying my client has to come for a hearing. And I'm like, wait a second, the judge terminated this case. And this doesn't make any sense. And once a case is terminated, you can't just get put back into proceedings like that. They have to reserve you with a notice to appear in immigration court, which is not done by the judge. It's done by the Department of Homeland Security. So that didn't happen. There wouldn't have been a reason for that to happen. It seemed as though the judge got confused, because I think there was something referenced about on top. He wrote a note like, we never filed a motion to terminate, when, as I just told you, there was a whole to-do about the motion to terminate because of the calendaring. We definitely filed it. We definitely had it approved, but the court had mixed up the file somehow. And because the judge didn't have the file in front of him, things got confusing for the judge. So I get this notice, and this is when the courts were closed too, mind you, because of COVID. And I write the judge a letter saying, Your Honor, you terminated the proceedings. Here's a copy of your order. My client already filed his I-485 with USCIS. I'm not sure what the confusion is, but, the fact of the matter is, you get a hearing notice, whether you've received that notice to appear or not. If you haven't heard from the court otherwise, you have to go, if the court's open, of course. And the reason you have to go is because you don't want a removal order, even if it's a wrong removal order and it's an error and it's going to be changed. It's going to cost you more money, more stress, anxiety, and can possibly delay everything else for you. So if you have anything that's slightly off with your file in an immigration court, you need to get it fixed. So when we saw this, I wasn't panicked. I knew, hi Farah. I like the wave function on the Instagram. I knew that my client wasn't in proceedings, but I also knew if I didn't hear back from the court before his next hearing, we were going to have to go to court. And as much as frustrating as that is, that was the right thing to do, because I didn't want my client to get a removal order in absentia for not showing up. And now we got to file a motion to reopen. It would have just made everything crazy. However, the courts were closed and I didn't hear back. But then I got a second hearing notice and I wrote a second letter to them. And then finally my client got an interview notice with USCIS, and he went to his interview. And then we had another problem because his wife their son was sick, and she had been trying to get him this appointment with the doctor for a while. And of course, she finally gets an appointment the same day as the interview. And the doctor had nothing else available for a couple of months. So I told them, look, I don't know what to tell you to do. I mean, if right now they're being very lenient about rescheduling, and that's true even today. This was a couple of weeks ago because of COVID. So if you are worried that you were exposed to COVID, then we tell them that you're worried you were exposed to COVID, or your wife, or something like that. That's completely legitimate as long as you're telling the truth. Not a problem. I was like, but otherwise, if we can get a letter from the doctor, we can show it to them. But remember, I've been talking for a while now, but this is the same client who got in removal proceedings in the first place because his wife came late for the interview. So he's been waiting for a while. We did not want to mess with rescheduling. Fortunately, his wife was able to reschedule the doctor's appointment. Finally, she did get a note just in case. They went to the interview. They did great. And my client finally got his green card after all that time. So now the court proceedings, we've not, the second court appearance, like I said, passed because the court was closed. We've not heard anything that he has court since, but it's actually a little easier now. If we get another hearing notice, then I just send in a copy of his green card showing them he's a valid permanent resident and he shouldn't be in proceedings. And that should take care of that, along with the motion to dismiss. I actually don't anticipate a problem because New York's been open now, so we haven't heard from them. But I won't be surprised down the line if we do. So my client had a very stressful road to his green card, and because the first one was denied and he had to refile, by the time they had the green card interview, they were married for more than 2 years, which means instead of getting a 2-year green card, they got a 10-year green card, and he doesn't have to apply for the petition to remove conditions on his residency in 2 years, but he will be eligible for citizenship in 3 years if they're still married and living together. So, I tell people everything happens for a reason. It was stressful. It was a lot to deal with, but it is nice to get the 10-year green card and not have to worry about the petition, the I-751 petition, in a couple of years. So just to recap real quick, what was so notable about this case, first and foremost, this was the client's second filing with the same spouse. And the only reason it was denied the first time around is because his wife came 3 hours late to the interview, which is the equivalent of saying she missed the interview. Now, that doesn't look good, of course, but it's also not necessarily fraud. However, this was their second interview, which means they were already questioning the marriage. So it wasn't a good look. But again, that doesn't mean you can't get it approved. It doesn't mean your marriage isn't real. It just means that you got to try again. And he was unlucky that less than a month later, he was put into removal proceedings. So then we had to deal with that. But then he got lucky that his case was terminated, and his I-130 then was approved, the marriage petition, without another interview. And then he got unlucky again when the judge forgot he terminated the case, but it all worked out in the end because now he has his green card. So that is all today for notable approvals. Don't forget to like us, follow us, Facebook and Twitter. Feel free to share these videos with anyone you think that will find it helpful, and comment if you have questions about your own case. Our contact information is scrolling across the bottom of your screen. We'll be more than happy to help. And we have some real good cases this week to talk about. I'll be back tomorrow with another one. Have a great day, everyone, and stay safe. Thank you for watching.